A lot going on there. Josh Ritter, luckily, is here. Criminal defense attorney, great criminal defense attorney, former partner of Alan Jackson, if I recall, host of Courtroom Confidential. As you know, I tried the Phil Spector case with Alan. He was absolutely right, Josh. This morning, I asked my producers to get me that first verdict slip when he said, there was no not guilty on the side. He was guilty, but there was no not guilty. All these charges. And the judge got mad at him. But he advocated, and she obviously went back, talked to somebody else, and then at least recharge the jury that, hey, they have an option of not guilty. Give me your thoughts about this and how hard it is to be an advocate when the judge is really coming down at you, yelling at you almost.
Yeah, well, he's no stranger to that. I mean, he's not going to be intimidated by a judge. I don't care if he's out of his jurisdiction or not. If he feels he's got a point to make, he's going to make it, especially in advocating for his client. But I agree with you. The form, I understand, I guess, what the form is asking the jurors to do, but it's not clear. I mean, I'm used to forms, and I'm sure you're used to verdict forms, where it gives a separate option on every single charge, guilty or not guilty, and then you move down to the next charge. And that's the problem here, is they need to understand that if they want to move down to the next charge, they need to have already acquitted her of the charge above that. And so this creates a problem where they might not know that they have options
to acquit.
They need to acquit. Correct. So it only gives one option for not guilty. It's almost like the form should have said check only one box.
Right.
And maybe that would have clarified things. But it is a little, especially if you're used to practicing in a different jurisdiction like Alan is, this is just not something we're used to seeing. I'm used to seeing all of the different charges on separate forms individually so that there's not all this confusion that you have kind of a pick your poison option on one form.
Right. And also, she said that she needs to change some commas and all. I don't think the commas are what's going to do it, but we all thought this was going to be a quick verdict. But looking at these charges, the jury gets in there and says, wait a second, we think she's not guilty, but maybe what do I have? Motor vehicle homicide, then I have involuntary, and I have manslaughter, operating a motor vehicle under the influence. And somebody could say, well, you need someone to stand up and say, well, isn't the first issue, did she hit him? Right, Josh?
Right. Absolutely. And then that's what it comes down to. I mean, what was so remarkable to me about the closing arguments is neither side talked about the elements. We never saw a verdict form or heard about any of the elements involved in this crime, because for both sides, prosecution and defense, it's come down to, did she hit him or not? And they're just kind of leaving it up to the jurors that if you think that she hit him, then pick the crime that you think she's committing. But the defense is all in on the idea that she never hit him at all. So they never even really got into discussing any of these lessers, because in their view, there was no crime whatsoever.
Right.